Good evening.
Good evening.
It's another Friday at 6 p.m., and you are here at Courtside with Lawman,
And Carmen B.
and we are here to talk about the criminal justice system and issues that affect the public involving the criminal justice system, as well as other relevant news.
And when we talk about these things, we do not create attorney client relationships because we answer questions with anyone. We are trying to answer them in a general fashion to give you general advice. But if you needed specific advice, we are available for such things.
And actually, it's not actually advice, it is information that we
True.
are providing. This is an informational and educational channel to educate the public about issues related to the criminal justice system.
Now, is there a number that people can call in order to talk to us,
Yes, there is a number
ask
that people can
questions?
call in. That is 916-384-8204. Again, that number 916-384-8204.
And I believe you can chat with us and send your questions and your thoughts and things like that, and we'll try to deal with every one of them.
Yes.
Now, tonight, Carm, we're still doing trial, I think. We're in the middle of maybe picking a jury or just pick the jury.
Yes, we're doing criminal procedure 101. So these are some of the basics dealing with uh, being charged with a crime and proceeding to trial. During the last episode, we were talking about jury selection and things that impact jury selection. And I think at this point, today's show, we're going to move into talking about what happens at the jury
Trial,
trial.
yes. And we do have some comments on jury selection that we'll talk about later, the new laws and things like that. We want to remind everyone that right now in California, a felony does not prevent you from serving on jury service. So we go now into a trial. A trial actually starts. Well, the first thing that's going to happen is the judge will allow both parties to make what's called an opening statement. Now, an opening statement is not a magical statement that's designed to show you all of the facts and why they're true, but it is a roadmap that the lawyer should use in order to preview the things that the jury is about to hear. Right, Carm?
Yes. And actually, the trial has already started. The start of the trial is when you're assigned out to a courtroom and the attorneys discuss motions with the court. Jury selection is part of that trial process. But now we're talking about the what is going to be the start of the evidentiary process of the trial.
So, what you say in opening statements as a lawyer is not evidence ever, but you're alluding to what may come soon and what the jury is going to see or hear. So, it's important that the lawyer does not argue their case in the opening statement. Now, at this point, what you're doing as a defendant is you're pretty much sitting there and you're looking the best you could and you're watching. You're watching the jury as your lawyer speaks to them. You're watching the jury as the DA speaks to them. And you're seeing their reaction to different things like subject matter. If it's a shooting case, you voir dire them about guns and things like that. But now they'll hear a little bit of what's going to come at them in terms of the evidence and listen to a lot of people who will testify about them. And so your job is to sit and pretty much watch what's going on at all times. It'd be good to have a yellow pad, something in front of you, and a pen so that you can take notes to yourself and pass them to your lawyer.
That is accurate. That is accurate. During the When the attorney does the opening statement, this is something that they have prepared for in advance. They are aware of what the issues are in the trial relating to disputed facts. And so that is the discussion that occurs. The opening statement is just telling the jury what you believe the evidence is going to show.
It's often called storytelling in a way. If you can tell a story, that's an opening statement. So once it's and the prosecutor will always go first because they have the burden of proof. They're always going to start off the trial with their opening statement. your lawyer as a defense, it is actually optional that you do an opening statement. Now, I'm of the position that you want to talk to the jury right up front. You want to be able to grab their attention with your story up front so that they're not waiting the whole trial to figure out what your defense might be, what you're going to say. Now, you don't always have to say whether you're going to testify as a defendant or not. That actually, you're right. It comes down to what you choose to do and your lawyer chooses to do. And sometimes you don't want to come right up front and say that your player or your defendant is going to testify right away.
And let me say one other thing about that. I never refer to my client uh, during trial as the defendant. I refer to them as my client. And I try to get the jury to think about if they themselves were in the position of the accused. Now, the district attorney is going to refer to my client enough as the defendant, and there is a negative connotation that attaches to that. So I will refer to my client by their name or as my client.
And usually it's a good habit to refer to everyone by their last name or surname, like Miss Smith or Miss Johnson, things, or Mr. Johnson, because it shows some sort of courteousness about with everyone, and everyone's put on the same plane in a way.
Yes. Additionally, there are some judges who will require that. They will not allow you to refer to witnesses by their first names only,
True.
which usually you should not do anyway. You should give them the courtesy of calling them by their proper last name.
Right. And there's even a battle over whether or not a person who feels victimized from a crime would be called a victim or not during the crime. It's something that your lawyer would square away with prior to the trial starting as to what to call the person who seemed to be victimized. So even the use of the word victim could imply that the crime has already occurred and the person has already suffered. Therefore, the presumption of innocence, which is key, kind of withers away at that point. So once the opening is done, it's time now for the presentation of evidence. And who goes first, Carm?
The prosecution goes first because they have the burden of proof.
All right.
I would just ask whether or not we are coming through loudly. I did receive a text indicating that we were coming through rather quietly.
Mhm.
And initially, we did not have the mic plugged in. The mic is now plugged in. So if I can hear from someone in the chat, whether or not they can actually hear us.
That would be kind of important, I guess.
Otherwise, we've just been talking all this time to ourselves about something that we already know about.
True. So, prosecution now has an opportunity to start presenting their case. And they're going to do it through calling witnesses. So, they will call witnesses in the order they choose to call them. And a lot of times it depends on timing when the person's going to come. And each time they call a witness, they do what's called a direct exam. A direct. I like to think of a direct exam as who, what, when, where, why, how questions. You're trying to get a story out by saying, what is your name? Where do you live? What's your occupation? What happened on this particular day? Who did what to you? You see, things like that. And then once that's done, the cross examination begins. And that should be done in a whole entirely different fashion. Cross exam should involve closed end questions. You want to lock a witness down to a yes or a no if you can. And when you're really skilled at cross examination, it flies through and the witness doesn't even know that they're being locked down to yeses and nos. So the skill of your cross exam is very important because I remember trials, Carmen, you probably had them, where you had other lawyers, co defendant lawyers, and right after the victim or alleged victim gets up and tells their whole story and they're crying and everything, and they get done, they wipe their tears away, another defense lawyer will get up and actually ask the same questions that the prosecutor did. They would have them actually tell the story once again. So a skilled cross examiner does not replay the story that the person testified to. They will crash into the story, pull out of the story what they need, expose it, and then put it back, so to speak. So once that occurs with one witness, it will occur with every witness. And it will go back and forth until there are no more questions of that witness. And then there's a magical, can this witness be excused? And that's where, if you're not going to use that witness in the future, then you could excuse that witness. But it's a good time to keep that witness under subpoena if it's time to excuse them, because a judge can order that they stay available. They may be called back to this trial at any time. So once they're gone, though, prosecution now, their duty, call the next witness. And it goes in that pattern until the prosecution decides to stop. They are calling no more witnesses. And when that happens, there's a magical change that occurs whereby now the attention is on the defense. If your lawyer did not do an opening statement before, now would be the time to do it. If you have witnesses that you will call, now would be the time to do it. If your lawyer is going to call you as a witness, now would be the time to do it. Now, I'll tell you something. You do not have to testify against yourself. You do not have to at all. It is a major right that you have in the Fifth Amendment. But if you and your lawyer feel that you should, then preparation is the key. You do not want to get to the day of trial and you and your lawyer have not prepared what you are to talk about and how it's to come out, right, Corn?
Are you talking about the client
The
deciding to
client.
testify? Yes, there should be plenty of preparation, and there is nothing wrong with discussing your testimony with your attorney. In
Correct.
fact, that should occur. You do not want someone testifying that you have not discussed their testimony with them in terms of your client. Other witnesses, that is a different story. There's a different relationship, but there is an attorney client relationship with a level of confidentiality that allows the client to discuss everything with their attorney.
And your attorney should at least give you a roadmap of where they're going to go and what they want to talk about. And you should know your case enough to be able to know, oh, you're asking me, did I walk into the house without permission? And the answer would probably be no, I did not do that. But you and your lawyer should work that out before that trial begins.
Well, there should be many, many meetings, many, many visits with the client. If the client is in custody,
Custody.
if the client is out of custody, there should be many, many meetings between the client and the attorney to thoroughly discuss the case as well as to discuss any potential testimony that the client may give.
Now, Carmen, here's a key part. What if I don't want to testify and my lawyer wants me to?
The ability to choose to testify or not testify belongs entirely to the client. So that there are other aspects of the defense that the attorney has complete control over. That particular aspect, the client has complete control over, and they decide whether or not they're going to testify or not.
So that means that even if my lawyer doesn't want me to get up on the stand because I've got a prior record, I can decide to get up on the stand.
You can, but your attorney should have discussed thoroughly with you the reasons why it is not a good idea to testify. There can be numerous reasons why it's not a good idea to testify. It could be that the person is just so nervous that they're not going to testify well. I had a client who, after every question that I asked her, she would giggle uncontrollably and she could not control it. And I knew that if she testified on the stand, the jury would view her as not taking this case seriously rather than realizing that she actually just had this nervous habit.
Wow. Can I ask you a question then, Karen?
You can.
What if? So you're saying that basically my personality, just the way that I am, could be a reason why you do not want me to testify.
Yes, and it's again something that should be thoroughly discussed between the attorney and the client. Um, I had another client who had a stutter, um, but it was very important, and I explained to him why, that he take the stand and tell his version of what happened. And he did that, and he was able to get through. And there were times when he was nervous and his stutter came out. But I had asked him about that in advance when I'm introducing him to the jury during that initial testimony, asking his name and where he lives and where he works and whether or not he has that speech impediment. That way, I've already notified the jury that this is why he is stuttering, not because he's lying, not because he's not telling the truth, but because he has the speech impediment that he's had his entire life.
So if there's something negative about me, like my criminal record or something like that, will my lawyer pull it out first?
Your attorney should, if you are going to testify, should address that issue with you. We call it stealing the thunder, rather than letting the other side bring out the fact that, oh, isn't it true that you have a felony conviction from 1985, right? Instead of letting the prosecution ask that question, the attorney should ask that question of their client. So it's brought out, hey, jury, my client does have this prior record, has nothing to do, right, with what happened on the particular date in question and his ability to tell you the truth about that incident.
And that's one of the things that I think the law allows the jury to take into consideration is a person's prior criminal record. But most of the time, that criminal record doesn't apply to the facts of the case. And it can be very prejudicial if you're trying me for stealing something and I have a bunch of theft related crimes and they get into every one of them. So the jury would the presumption of innocence starts slipping away because the jury is thinking more about my prior thefts than the one that I'm being tried for. So let's see. Oh, when should that decision be made? Whether I should get up and testify, Carm. When do you make that decision?
Well, it varies, right? There are some cases where you know well in advance that your client is going to have to make the decision to testify, or at least that it's in their best interest.
What about
There are other
self defense?
times,
What about self defense?
there are other times, and I'll get to that. There are other times where you can wait and see how the other evidence comes out. And it may be that your client does not need to testify because there is someone else who has testified who has given the same version of events that your client would give should they testify.
But he was in self defense, and I need to say that.
In a circumstance, well, it depends. Again, on a self defense case, there are a lot of times where your client may be the only person who can testify about what transpired and what was in their mind at the moment that these events happened. But sometimes there could be someone else who also witnessed everything that happened and establishes enough information that sets up the self defense.
I've heard a lot though about how the jury needs to hear from the defendant. They want to hear your side of the story, right?
Well, they are given a specific jury instructions that tell them what evidence they can consider and to a certain degree how they can consider that evidence. So, back again to whether or not your client has a record. First of all, the judge has to decide whether or not he is going to allow that information to be used to impeach your client should your client decide to testify.
I heard that
And
word impeach. You got to explain that later.
that ruling will be made prior to your client taking the stand. And impeaching is what it basically means attacking a person's credibility. There's a jury instruction that talks about a number of factors. It's not all inclusive, but factors that the jury can consider in determining a witness's credibility. And one of those things that is listed is whether or not the person has suffered a felony conviction.
Well, and I'm going to answer a question on this one. What if I have a certain religious background or belief, and so I have to wear a certain item or I do a certain thing?
Are you talking about in reference to the
Me,
accused,
uh, me testifying.
the client
Yes,
testifying?
exactly.
So, if it should not play a factor, that's not something that should be considered. Oh, this person is a Christian, therefore I'm going to discount their testimony. But you never know what a juror is thinking inside of their head. If someone does have a religious background, let's say a religious background that requires them to wear certain attire, you can address that again with them in the initial testimony where you're kind of introducing them and who they are to the jury.
So,
For
so
example, I see that you have on what is it
a
called? A
yarmulke?
yarmulke.
Yeah.
Yeah.
Okay.
And they can explain, yes, this is my faith. I was raised this way, and we wear this for this particular reason.
And if I was Rastafarian, then I would grow my dreads, and my dreads probably could be wild looking. Um, would it be smart to maybe bring out that maybe that is part of my religion and my belief?
Yes, and again, that's what you would do in the introduction of your client in those initial questions where you're establishing who they are, where they work, what they do, those sort of things. And sometimes you have a client who is very young, so they haven't even had a chance to have work history yet. Then you talk about the fact that they went to school, where they graduated from school, and how old they are, so that the jury has an understanding that this person has no work history because they're too young to have worked yet.
Yeah. Well, and will a jury? Well, what if I uh, talk too loud? What if I, what if I cut off a person and stuff? And what if I show emotion on the stand? Is that good or bad?
It all depends on the particular circumstances, whether or not the client shows emotion. It depends on the particular circumstance. You don't want your client up there as if they are acting, because the jury will see right through that. But if it is genuine emotion, they are allowed to show it. Accused people are humans. They have the same feelings that we all have. So you may have someone that's on the stand where it's so emotional that they actually break down in tears. And that's okay.
And 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 when I'm on the stand, it's scary. So should I be looking at my lawyer, or should I be looking somewhere else?
Well, you should look the accused should look at the place that is most comfortable for them to look. But I will tell you, when we know that witnesses are taught, and by witnesses being taught this, we're talking specifically about expert witnesses as well as law enforcement officers, that when they answer a question, that they look at the jury and answer that question. But you want to do that in a way that is natural. You don't want it to look like, oh, my attorney has asked me a question. Now, like a robot, I will turn to the jury and answer that question. You don't want that persona. You want to be as natural as possible.
And are you looking at the jurors so that you can make a connection with them?
That is the reason, because these are the people who are going to decide whether or not they believe what you are telling them about what transpired. And we know there is no magical halo that comes over any witness's head to let the jury know that this is the person who is telling the truth about what happened. And we know that because there have been many, many, many innocent people who have been convicted at jury trials.
Well, there's a question that came through too that it's the prosecution's job to prove a defendant guilty, not the defendant's job to prove their innocence. Is that the presumption of innocence and the burden of the prosecution in a trial? Is that what we've been talking about?
You'll have to ask me that again. I'm sorry. I was looking at a question that was coming through.
No, no problem. But it's based on the question from Zimbabwe, and they ask about the prosecutor's duty and job is to prove a defendant guilty, and not the defendant's job or the attorney to prove the person innocent. Now, is that presumption of innocence that we talk about and the burden of proof that goes along with a trial?
It is, but as we've said before, there are many things that, if we lived in a perfect world and everything happened in theory as it should, we wouldn't have to worry about those sort of issues. But we don't live in a perfect world, we live in an imperfect world. So, yes, despite the fact that it is um, innocent until proven guilty beyond a reasonable doubt, there is a certain level of proving that we have to do to the jury. Now, it is not written in stone, it is not written in law, but we know in reality that that does happen. And one of the things that Lawman mentioned is that jurors want to hear from defendants because they're thinking in their mind, if this were me, I would take the stand and tell them I didn't do it if I didn't do it. There is a specific instruction that they are given from the court that tells them they are not to consider whether the accused testified or did not testify, and they are not to discuss it in their deliberations at all. But we know that jurors are human, right? And so, even given that instruction, they may not discuss it in deliberations, but it still may be internally in their mind something that they are considering. But they are instructed by the court that they are not to consider that fact at all. And in fact, the defense can rely entirely upon the fact that the prosecution failed to prove their case. And not only does the defendant not have to testify, but the defense does not have to call any witnesses at all. They can rely entirely upon the fact that the prosecution failed to meet their burden of proof with the evidence that they presented.
Now, I'm a self-defense guy. I'm going to get up there and I'm going to prove my case because I did act in self-defense. How does that fit in with what you just said? Because isn't it true that I guess I got to testify if I'm going to use the self-defense because I have to tell my side of the story? How does that get told if I don't get up?
Unless there are other witnesses who observed everything, and each case stands on its own bottom. So there are some cases where the only person who can testify about anything leading potentially to self defense is going to be the accused. There are other cases where you may have enough other evidence that supports it.
Okay. But it is my duty, though. I have to prove some sort of self defense at some point, right? Don't I have to at least make some sort of what they call a prima facie case or something in order to even get a self defense instruction?
I mean, again, there has to be evidence that supports it. So if it's a case that shows that I, Carmen, walked up to Lawman and just shot Lawman in the face, and he was actually eating a ice cream cone at the time that that happened, there's no way that a judge in that instance is going to give a self-defense instruction because there is no evidence. If that is all the evidence, there's no evidence that I was acting in any way in self-defense.
Okay. So so now I didn't testify or I did testify, but once this case is over and defense is done, there are no more witnesses. What happens next?
At that point, then there will be closing arguments. And the closing argument is now where both sides gets to argue what the evidence has shown and how, from the defense perspective, the prosecution has failed to meet their burden of proof.
Now, is there a shouting match that goes on here? Is this something where they both get up and just debate each other?
No, this is not what you sometimes will see depicted in television shows. Each side gets their opportunity to argue. So it starts with again with the prosecution because they have the burden of proof, and then the defense will get to give their argument, and they will speak specifically about the evidence and witnesses that testified and how it supports the defense's theory of the
Hmm.
case.
Well,
And one other thing, the prosecution gets to argue twice. And the
ah,
reason they get to argue twice is because they have the burden of proof. The defense only gets to speak to the jury at the conclusion of evidence that one time.
Isn't that unfair though? I mean, I want the last word, or shouldn't I get the last word? I'm the defendant.
Unfortunately, that is not the process. The process is that the prosecution, because they have the burden of proof, gets the opportunity to rebut any arguments that were made by defense.
So I guess then that means that the lawyer, your lawyer, has to not only address all of the things the prosecutor may say, but all of the things that you have to propound to the jury.
Well, and sometimes you don't necessarily want to address everything that the prosecutor has said because sometimes they're just throwing things out there, um,
Sort of as a
to kind of,
distraction.
yes, to kind of
Yeah,
distract you. And so the attorney knows what's important in the case, or should know
yeah.
what's important in the case, and should address those important issues. And they should point out the holes that exist in the prosecution's case.
Now, is this where the attorneys are pounding and saying that beyond a reasonable doubt, you can't prove it beyond a reasonable doubt, and things
Well, I
like
don't
that?
know anything about pounding. Every case depends on, every case sits on its own bottom. So there are some cases where the attorneys are going to be emotionally charged in their arguments, but there are other cases where they may not. In fact, I remember a specific case that I watched. I think that was yours, where the prosecutor in that case, in her closing, basically whispered her entire closing. And I believe the reason that she did that because it required the jury to really have to focus in and listen really hard because they could barely hear her. So there are strategies involved, and the strategy used depends on the specific facts of the case at the time. I remember a closing that I gave, that involved a client of mine who had been accused of an assault, and I had brought in the pipe that the alleged victim had in his hands, before he was struck by my client, and I let that pipe drop to the floor so that the jury could hear how heavy that pipe was that this person was going to hit my client with. And it had the impact that I expected. In fact, a couple of the jurors, when I let it drop, they jumped because it was that loud, because it was that heavy.
So using a little drama or using surprises and emphasis on certain things is kind of important in the closing
It is. It is.
because you want to leave the jurors when you want to leave their minds in or leave their minds in a state that they're going to apply the instruction and that all they can see is that the person is innocent. So,
That's what you want. And they should be thinking that from the very beginning, because, again, in theory, they are supposed to be applying that presumption of innocence.
well, what happens then once they're done with closing argument? What goes down then?
After closing arguments, the jury is, the bailiff, actually, or deputy in the courtroom, is sworn to take the jury to a location where they can deliberate. Um,
Do they stay there overnight?
Not here in Sacramento. That would be, extremely rare. I suppose there could be a circumstance where that happens, but that is extremely, rare. That would take a special kind of case, for that requirement. I understand that that does happen in other jurisdictions, but here, basically, the jury deliberates until 4:30 p.m. They're allowed to go home. They resume deliberations the next morning. At 9 a.m., they're allowed to take a lunch break, and they're also allowed to take, just rest breaks, like 15-minute rest breaks. And they again deliberate until 4:30, and that continues each day of the deliberations until they've reached a verdict, or until they've come to the conclusion that they cannot reach a verdict.
Well, and if I'm a defendant, what am I doing all that time?
Waiting, patiently waiting. Usually, the court will require that you be no more than 15 to 20 minutes away from the courthouse, such that if there is a verdict, you can get back to the courthouse quickly. And the reason for that is, the jury, members have already been inconvenienced by performing this civic duty, and the court doesn't want to have them to have to wait unnecessarily and have to wait, 2 hours or 3 hours or some other inordinate amount of time for you to arrive at the courthouse.
And when there is a verdict, what happens then?
Well, the verdict is the if they have a verdict, they actually have verdict forms, and this is a form that they fill out. They get one form that they can sign if they have determined after deliberations that the accused is guilty. They get a second verdict form that they sign if they have determined that the accused is not guilty. When they are indicate to the court that they have a verdict, they are returned to the courtroom. They bring in an envelope that has the signed and the unsigned forms in it, and they provide that to the court clerk, who then passes it to the judge. The judge normally will open the envelope, review the verdict forms, and then hand them to the clerk for her to actually read officially in open court on the record.
Well, that's the stuff I see on TV all the time, right? Is that verdict reading and stuff.
Yes.
Okay. Well, what happens if I'm guilty of something? Do I just get thrown in jail right away?
It depends on the situation. Yes. There are times, well, the court will immediately take you into custody. There are other times where the court may allow you to continue to remain on your OR or on your bail. It depends on the type of case, it depends on your background, and it depends a little bit on the judge and whether or not the district attorney is demanding that you be taken immediately into custody. The more serious the case is, the more likely the odds are that you will be immediately taken into custody after a verdict.
And I guess if it was a matter of violence or using weapons or something, that would also go to whether or not they will lock me up after.
Yes, because
Okay.
again, that relates to the seriousness of the case.
Okay. Wow. You know, this has been a long ride, this whole trial thing, Carm. Man, I'm gonna, you know,
And trials can take they can take a very long
yeah.
time. I mean, um,
Well, 4 weeks, 5 weeks. I mean, how long? What was your longest trial?
they my longest was probably about actually only about 3 weeks.
Wow. I had one that was probably about 3 months long. And so, yes, they can vary. I mean, 144 witnesses and things like that. But once they're over, it can take a toll on people. It can, it's a tough thing to go through.
It can take a toll. It takes a toll. I think it takes a toll, even if your client is found not guilty. I have had clients who, at hearing the words not guilty, break down because they have been so stressed, not knowing what was going to happen to them.
Yeah, and that's a. I guess I've done that moment so many times. You kind of, for me at least, I go into a surreal world, where I'm just waiting for that moment in time. And I always tell my clients, don't react. Don't react. Just try to stay calm, try to stay cool, and don't react. Either way, if it's not guilty, you be proud. If it's guilty, you stand proud.
Yes, you want your client to remain stoic, but at the same time, you realize that this is an extremely emotional situation and that they have been under a great deal of stress.
It
Now,
takes
you don't want them to act out if the verdict is what we don't want it to be, which is a guilty verdict. You
right.
don't want your client to act out. You don't want them to yell. You don't want them to scream. You don't want them to curse because there is still more to come. And that is the sentencing phase, which in Sacramento County usually does not happen right away. The case is usually referred, if there was a guilty verdict, the case is referred to the probation department for them to prepare a report and a recommendation.
Okay. And then that time at sentencing, the judge would come out and I guess decide what you're going to get, and your lawyer will have a chance to argue about that sometimes. Um, and then it's done. Everything is done. It's just over with. Let's say I'm guilty. I found guilty of something. It's just over with. They take me away. And what happens then? I mean,
Well, as I just explained, that usually it will be referred for a probation report. So there'll be another court date that transpires after that court date.
but that's sentencing. When that's done, he gives me 15 years. What happens?
Well, your attorney should file a notice of appeal. and you should be assigned appellate counsel. If you cannot afford counsel, if you can hire counsel, then that counsel would represent you. And then that appeal will move through the appellate courts um, until they make their decision.
What if my lawyer says, "Hey, yeah, don't worry, I'll file that appeal for you," and it never happens?
Well, that is problematic. That would, well, the notice of appeal is required to be filed. I believe it is within 60 days
Yeah,
from, is it 60, right?
60. Yes,
From the date
the verdict.
of the judgment, not the verdict, but the judgment, the
Yes,
sentencing,
sentencing. Yes.
judgment and sentencing. Um, when you say that they don't, you mean they don't file
Yeah.
the notice,
Well,
or they don't
I'm
file,
about
or
to go
they
to
don't
jail.
file the.
The notice, because I'm about to go to jail. I can't file it, so I gotta trust the lawyer just to file it.
Yes, and if the attorney, you do, I mean, you can on your own attempt to file a notice. I have had colleagues who the client themselves has filed their notice. But yes, if you're concerned that your attorney is not going to meet the deadline and not going to file it, then you can attempt to file it on your own to make sure that there's something in the record. If the attorney fails to file it, what would that be?
Ooh, that might be a waiver of all the issues that occurred at trial.
But what is it if the attorney should have filed it and did not file it? What is that? What?
Oh, what do we call that?
Yes.
Ineffective assistance of counsel.
Yes. So if the attorney did not file it and they should have filed it,
Yeah.
you will still have an appellate issue in terms of that.
Now, I'm not going to go into the appellate issues because it can be so varied. From the standpoint of even if the lawyer does not file that, realize that the first thing that's going to happen is you, the appellate courts are looking at it as well. No one filed a notice of appeal, so you waive everything, and you probably have to come back on other kind of techniques, which are called um, habeas corpus and things like that. Saying that I'm being held illegally because my lawyer screwed up real bad. Now, last thing, only thing I'll say on appeal is this: you only appeal legal issues. Factual issues are usually not appealed. That something new has come out, usually not appealed. But the legal issues are the things, the judge's rulings, every objection a lawyer makes.
Well, there also could be if there was evidence that was purposely withheld that you found out about at a later point.
What's that called? Brady? Is that
Well,
similar to Brady?
certainly if it is exonerating evidence that was withheld.
I would hope it'd be exonerating because if they found bad stuff afterwards, I don't think you're coming back. So, but in the recent case where Maya Moore, the WNBA ball player, uh, quit playing for the support of Jeremy Iron, or not Jeremy, but Iron, Mr. Irons, and in that case, what the problem was there was fingerprint evidence that would have exonerated him, or at least was favorable to him, that was withheld by the prosecution, and we call that a Brady violation. In that Brady is the name of the case that talks about how a prosecutor's duty is to turn over information if it is to be favorable to a defendant, whether the prosecutor believes it to be favorable or not. If it can be viewed that way, they must turn it over. And it's on that theory that he came back and they overturned his conviction because those are taken very, very, very serious. So that process is over. And you know what? I won. I'm not guilty. Woo! Are they going to come back and try me again?
They can't come back and try you again if you were found not guilty.
How come?
If there is a hung verdict, let's talk about that because we
Oh,
did not talk about that. A
oh,
hung verdict, meaning the jury could not unanimously agree. In order for there to be a verdict, all 12 must agree that the accused is not guilty or that the accused is guilty. If there are, and this is in California, and I know that there are some other places, I think Florida might have
oh,
been
yeah,
one of them, where they did not require unanimous juries.
right.
In California, the unanimous jury system is used. And so if there are 9 jurors who are voting for guilt, but 3 who are voting for not not guilty, and they are sticking to that. That is what is called a hung jury. And it doesn't matter what the split is, it could be 11 people voting for guilty and one person voting not guilty. That is a hung jury, meaning they were unable to reach a decision. In that circumstance, the prosecutor can decide to retry the
Mm.
case
You mean just right from the beginning, all over again?
all over again. And when we say all over again, we mean all over again. It's not going to be that same jury. The entire trial process will happen all over again, not that day. It'll be rescheduled for a date in the future. And a new jury pool will be brought in on that date. Jury selection will proceed again anew. Um, Opening arguments will happen, or opening statements will happen again. Evidence presentation will happen again. The prosecutor may decide to do it a little differently, may call some witnesses that they didn't call before, or may
Hmm.
decide not to call some witnesses that they did call the first time. The same in terms of the defense. The defense may decide on this occasion to present evidence where they did not before. Um, the accused could decide to testify where they may not have testified in the first trial. So it is an actual entire redo of the jury trial.
Well, how many times can that happen?
You tell me.
Ah, it can happen over and over again. My experience was I had a three strike case early in the three strike days where it was going to be 25 to life for any felony. And my guy was
If
charged
he
with,
was
yeah,
convicted.
if convicted. And he was charged with running from cops. So the first time, it was 11-1 guilty. So I had to retry it because the prosecution looked at it as, well, this is very serious. And I had 11 people. I know I can get one more. Well, we tried it again. 11-1 guilty. So at that second time around, uh, a great thing happened. And trial lawyers have got to watch out for this. The jury actually, when the trial is over, can talk to you. They can talk to your lawyer and they can tell you what they thought.
They're not required to, but they
Right?
can should
They
they
can.
choose to. So there are some instances where juries, or maybe not all of them, but some of them will wait around to talk to the attorneys. There are other occasions where the trial is over and they
They
get out of
fly.
there.
Yeah. And the I've had great results on jurors who hang around or who are crying in the end. You know, when they're leaving the bench or something, you know, and trying to approach them later, like, why are you crying? And so this time, though, it's 11-1 guilty. 11-1 guilty. And they want to try it again. And I'm now begging for anything but life. Okay. But they want to try it again. And here's what happened out of the blue. One of the jurors, the one who was the 11-1, not guilty on the second time,
The one who was
the one,
not guilty.
yes,
Hmm.
called me up, found me, called me up and said, hey, do this. Go see this professor and he'll talk to you about this certain subject matter. And I know this math professor who could spot out on a graph how fast something was going at a certain time by just using calculations. And he said that might help explain to the jury, you know, what happened here. Because my theory was he was going so fast, he couldn't have known cops were behind him. You see, so he had tunnel vision.
Hmm.
And sure enough, I went and got this person, this psychologist, a teacher, and I bring him in on a third trial and testify as an expert. I do a math diagram for every witness to say where they were at the time. And you wouldn't believe it, but it was 12-0 not guilty the third time around. And
So the
that's pretty
verdict
much
was not guilty.
not guilty.
All 12. Yes.
Yeah, after 3 rounds of going. I've had to do 3 trials on a case in YOLO one time, a gang case, where they just wouldn't quit. They had to keep trying it over and over again.
When you say they wouldn't quit, you mean the
Prosecution,
prosecution.
right? Wouldn't make a deal. Usually, sometimes, you know, they're going to make a deal or something like that, or dismiss it if it's like 11-1 not guilty. But sometimes it's not.
I will say my experience has been the closer that the split is, the more people who are voting for guilty, the less likely they are to dismiss it. An 11-1 case where 11 voted guilty and one did not is usually the kind of case that they're going to retry.
Oh yeah.
If the case is 6-6, that makes it a little bit less likely, but nothing is a guarantee.
Correct. And I've had those too, where they then ultimately do dismiss, but they can take their time and see whether or not they can change something, like call a certain witness, not another, and they assess it in that way. But it's totally up to them to retry it. So we're done with the trial. Everyone's happy. I'm free. I get to go home. Woo! Now, something came up recently, right, Carm? About because we're having this voting rights problem, and let's just reiterate once again that we all better stay aware of our voting rights and not let anyone take those things away. But there was a case out of Colorado recently where it was talking about a fair trial and getting fair jurors to serve on that. Do you remember that coming out, Carm?
I do.
You're
I,
pulling it up too. All right.
yes.
Now, this was in Colorado, and it was the Colorado Supreme Court that actually made a ruling. And I think the title, or at least the heading, was that the Colorado court is now hurting, so to speak, the opportunity to have a fair trial. Right, Carm?
Yes. So there was basically a new proposal that was aimed at addressing implicit racism in how juries are picked. Because you will have a prosecutor who says, well, I didn't kick that person because of their race. I kicked them because of this or this or this. But you will have other people on the jury who have those same factors, yet the prosecutor made no attempt to kick them. And so this was something to try and address that. And it was the kind of reform that actually, I believe, had already been adopted in the state of Washington. And it was based on that. But the court just rejected the proposal.
And so what that means is that the court is saying that, hey, we don't need that kind of tool, because there is this sort of presumption that all jurors are to be fair. All jurors, you don't need to have a differentiation between a race, religion, or anything like that. They're all going to be fair under the law. And that's not necessarily true. There are people who hold, and everyone does, a bias, some sort of reason to lean one way or the other. One of the major questions that are asked of jurors are, how do you feel about when a cop testifies? Do you automatically believe the cop? Or will you say that that cop is human just like anyone else and can make mistakes and can be wrong and can lie? So a lot of people, though, they will say, well, the cop doesn't have any reason to lie. The cop is here just doing his job. So I'm going to give him a higher level of credibility. I'm going to make sure that I pay attention to what he says and I follow it more than I would someone else. And that's completely wrong. And likewise, when we talk about picking a jury, and Carmen's mentioned it before, we'll get a jury panel of 50 people, and there may only be two black people in that whole
And
50.
sometimes there's only one.
Yep. And it's
And,
kind of scary.
and that's actually a panel of about, I believe it ranges from 65 to 70.
Yeah.
There
And,
was, oh,
oh,
go
go
ahead.
ahead. No, I'm just saying it's very scary when that happens. And if you argue right then and there, hey, judge, this panel needs to be disqualified just because of that, it's not going to get granted.
No, not just because
Yeah.
because as long as they
They
were
tried.
picked,
Yeah.
as long as they were picked randomly and there was
Right.
no purposeful exclusion of people of color from the jury
Right.
pool. There was actually a June 2020 Berkeley law report that found efforts to overturn dismissals of Black or Latino jurors rarely succeed. And I know that for a fact. I have
Yeah.
been practicing 28 years, and I think I have had one successful Batson Wheeler motion, maybe two, but one where they had dismissed an African American juror, and the judge required that we threw out the entire panel and we had to start anew, which was the right situation. But what the study is saying that The study examined 683 cases decided by the California Courts of Appeal from 2006 through 2018, in which a trial court denied the defense attorney's challenge to striking a black or Latino juror. In nearly 72% of those cases, prosecutors used their challenges to remove black jurors um, and Latino jurors in about 28% of cases, and the appellate courts only found that there was error in 2.6 of those decisions.
And just so that everyone knows what Batson Wheeler is all about, it's sort of goes like this. Let's just say there's two black people who get to the 12, and the prosecutor, when they use their peremptory challenges, kicks off those two people. Now, you can raise a Batson, you can say, hey, wait a minute, you know, I raised an objection to the prosecutor kicking those people off, and therefore the court now has to just question the prosecutor. Why did you pull those people off? Well, they can say anything. They can say, and most of the time they say, oh, they didn't like law enforcement. Their family has been in crime forever, or they have people in jail and stuff like that.
And one of the problems with that for African Americans is that our communities have been heavily over policed. And so, and we know from
Just studies
the criminal
reveals them.
justice system
Yes.
that whites and African Americans commit and use drugs at the same rate, but the punishment, the is
Criminalization.
yes,
Yes.
is highly upon the African American community.
Right.
So if you are African American, it is much more likely that you are going to have someone that you know or someone in your family who unfortunately has had to deal with the criminal justice system. And so it just is a way of making it easier to get rid of African Americans on the jury.
And it's stronger when there's when they kick off those two, and then you've got only one black person left back here, and that person gets on, and then they kick that person off, and you make that same motion, and you go through the same part of prosecutor explain why you did that. And what she's talking about is about the cases, and the study is that the appellate courts seem to just almost approve, or at least don't try to stop that type of random kicking off.
And it's not random. It's
Well,
purposeful.
it's purposeful,
Whether
but
it is let me perhaps it is not done purposefully. Maybe it is again, it is that
they have problems.
overt, right? It's that overt racism that we see.
Well, and I mean, wouldn't it also be implicit? Because let's just say, what if there are two or three white people that I don't kick off because they have people who are friends and family in prison?
And that is one of the things that you want to point out when making that motion. But again, once again, lawman, we are at the end of another episode.
No.
There were a few other things that I want to mention. I want to just tell our viewers because
Yes.
perhaps they can do Google searches. Um, there were funds that were supposed to help crime victims,
Mm.
but are not utilized to help African Americans. And because and this was, I believe, one of the cases was, numerous cases were out of Florida, but there's funding for helping people who are victims of crime, but it usually has a stipulation that the person themselves cannot have had a criminal background. And if they do, then they are disallowed from receiving the funds. So you could have someone who had a crime that happened when they were 18 years old, now they're 50 and they're the victim of a crime, and the crime fund will not be used to help them. So you can research that, and that is listed on the Marshall Project. The Marshall Project is another organization that discusses a lot of issues that deal with criminal law and with individuals who are incarcerated and the problems that they are having and that they deal with. Um, Another article that I sent you related to the lack of dental care that people in prison receive. Um, so if you just do
I
a
think it
Google
was called
search,
I Don't Have No Teeth, something like that.
Yes,
Yeah.
for someone who was in prison, who their teeth were actually pulled in prison because their teeth had gotten to the point of just complete decay and they hadn't received any dental care. And then the prison wouldn't even provide them with dentures so that they could eat
Eat.
with dignity. This is how humans are being treated in our society. And we have to stand up and say, this is not right.
Correct. All right.
And you can judge. Who was it who said you can judge
Mm.
a society by how they treat the least among them? Even if someone has committed a crime and they are serving out their punishment, they don't deserve to be tortured in that particular fashion. And if you've ever had a serious toothache, you know that that is some pain
It stays with
worse
you.
than childbirth. Worse than childbirth.
Wouldn't know that, but okay. I'll buy that.
But okay, do you have a tidbit of additional knowledge
On this
to
Friday,
leave on
let's
this
see.
Friday?
Well, I always say, watch out for each other. Let's all stay aware. When situations do arise, we counsel over and over again. Police show up at your door, police stop you. What you should do is you control the conversation by saying, am I free to leave? And that controls the situation from consensual to now a detention. And if you ask for your lawyer, those are magical words that they should not question you again. And you are
And
showing
and
that
even if
you
they
know your rights.
even if they do question you again, you know because lawman has told you the only words you should be saying if you are detained, I want my attorney.
That's right.
I want my attorney.
That's
I
right.
want my attorney.
And I also find, you know, this is something that you've got to, when we're telling you this and you go, yeah, 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 I know. And then one day, shockingly, a cop shows up and you forget everything you know.
Don't
So,
forget this. You
right.
need to exercise that. Am I free to go? If you're not free to go, you're being detained.
Yes.
Ask for your attorney. You don't have to know the name of your attorney.
That's right. I'm not flying in right away. But it is something that you always have to keep in mind so that you remain cool, calm, collected at the time of a crisis.
Yes.
So, we so appreciate that you sit here on a Friday and hang out with us and talk about the legal system, the thing we've spent most of our lives in now. Um, we hope that you can bring us subject matters to talk about. We'll talk about anything, right, Carm?
We will. We will.
And we'll try to talk about it in a very fair fashion. But we also got to point out inequities in the law and things that we see that may be going wrong in the law and how we can actually change things. So,
And our Instagram name, if I haven't stated it before, is at Courtside Channel. So you
so
can
tell your
follow us
friends
on Instagram as well.
and bring your friends along. Have a party on Friday night. That's what we should probably do is have a party and a t-shirt giveaway and all that kind of stuff.
Yes.
All right.
We thank you again for your viewership. Thank you for spending your evening at Courtside with Lawman
And Carmen B.